What's your name, sir?
Name is Deshaun.
Your last name, sir?
Last name.
I'm sorry, are you Deshaun Thompson?
Just Deshaun.
Ms. Roberts?
Your Honor, my understanding that we do have a Deshaun Thompson on the list today. That we interviewed somebody named Deshaun Thompson, and I guess at this time, I heard the court ask this gentleman if he's Deshaun Thompson, and he's indicated just Deshaun. So I would need an opportunity to go in a breakout room with this gentleman to get further clarity, please.
Okay.
If you want me to, Ms. Roberts, you can send me the sheet. I'll go to breakout room so you can continue the docket.
Perfect. Thank you.
And gentlemen, we're going to try this again. What's your name, sir?
Ready?
Yes, sir. You, sir.
Deshaun.
Mr. Reagan.
Yes, sir.
Apparently, Mr. Thompson wants to get a very large bond and not get released.
Just trying to figure out how could I need the prosecution to bring forth how could I be charged with not identifying myself with fingerprints if I didn't have a charge to even identify to begin with.
Yeah, so Mr. Thompson,
What's the purpose of me identifying the fingerprint?
Mr. Reagan?
Yes, I'm just saying, Mr. Thompson, judge, does not want to give his full name. I know that we have a complaint here as Deshaun Thompson for refusal to fingerprint. He's refusing to fingerprint. That's why we are before this honorable court this morning.
Yes, that's against my constitutional right. Though I don't have to do that. I don't have to enter into a contract. I don't have a legal name. I don't have a legal name with the state. That's
Mr.
against
Reagan,
my constitutional right. All statutes are not law.
We've heard you enough, sir. We've heard you enough. Mr. Reagan, is it
Yes, sir. I've advised Mr. Thompson of his constitutional rights of the charges and maximum penalty. You know, I can just tell you, Judge, that the complaint I have is for Deshaun Thompson. You know, and I have you know, spoke with Deshaun. He is not, you know, giving me his last name. I don't know if they have him in custody. All I can tell this court is that's where we are at this point, Your Honor. I can just tell you what we've done to this, where we are, and that's where we are, Your Honor.
All right. Well, the court will proceed as if this is Mr. Thompson. It's unfortunate that he's taken the position that he's taken, but we'll do this anyway. So you've got some tickets, sir, where you missed some court dates. When you miss those dates, the judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. You've got several matters, traffic matters here, and they start with ticket P 1387200, charge of driver's license never required. P 1387498, open alcohol in a motor vehicle as a driver. And ticket 4328813, no operator's license on person, no insurance, misdemeanor, and unregistered motor vehicle. These are all misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or $500 fine. I'm going to set aside the arrest warrants, enter a not guilty plea on your behalf, and give you a personal bond. Your next court date is a pretrial July 15 in front of Judge Garrett here in 36th District Court. Your other matter with us today is case 24044903, State of Michigan versus Deshaun Santo Thompson. Counsel.
Thanks, Magistrate. Good afternoon, Steve Vinson for the people, Peace 71917.
Judge, I just want to point out that, you know, this is a charge of refusal to fingerprint. There's no underlying charge. You know, to talk about. So Judge Fulbright, on behalf of Thompson, we waiting for reach new rights as to this particular case.
Thank you. Court will enter a not guilty plea on your client's behalf as to bond, beginning with Mr. Vincent, please.
Thanks, Magistrate. We're going to be asking for $10,000 in cash. We're also going to be asking for a tether as well as house arrest. The charge here is failure to provide fingerprints. So the defendant right there, allegedly, Judge, didn't want to have his identity confirmed one way or another. And now, interestingly enough, we have a defendant who's being charged with his failure to provide his identity in front of you right now, not even wanting to give Your Honor or the court his legal name, which gives the people pause, makes the people concerned that this defendant may be trying to hide something. Now, as a direct result of that, we feel as though this defendant is a danger and that he does pose a danger for obvious reasons. If somebody doesn't want to reveal who he actually is, either legally or through fingerprints. Now, with all of that being said, Judge, based on the court rule, dangerous.
That's against my constitutional right. I don't have to give you guys fingerprints. Every statute is not a law. If it's contrary to the Constitution, it's not a law. I can act with impunity.
Again,
So
Judge, more behavior that's making the giving the people pause. Now, in addition, I think he is trying to act as though he's a lawyer, understand the idea that statutes are not laws. It's very scary, and it really is. It makes him a danger to the community. And respectfully, Judge, we're going to be asking for that cash with monitorization.
And Judge, no assault has been committed. I do understand that there's a procedure for everything. You know, Judge, I believe to the court, I'm not asking for any cash bond. I would ask for personal, Judge. I don't know how the court wishes to proceed in this matter. We obviously look to the court, Judge. It is what it is, Judge. We're here. And, you know, like I said, no assault has been committed. There's not even a charge outside of this refusal of fingerprint, Judge. So we obviously ask that he be released, Judge. With no charges pending. There's nothing even charged with it, Judge. So that is our position, Judge.
And their officers were trying to investigate some type of assault case, which was why he was in DDC in the first place. And now we've got this refusal of fingerprint case, and we've got a performance before the court, which is, I think, quite telling. So here are the conditions of bond. You must be fingerprinted before release. There will be a GPS tether. You'll be on house arrest on that tether should you post bond. Court agrees with the people that without confirmation of this gentleman's identity, there could be other significant implications. For that reason, court will set bond $100,000 cash for surety.
$100,000 bond.
That's correct, sir.
Crazy. So now you're doing things out of spite.
I give you a bond redetermination.
You don't want to stick to the law.
Sir,
So,
now it's not the time to talk.
You're not holding your oath to the Constitution?
All right. So we'll have a bond redetermination hearing in front of Judge McConico on Thursday, June 20th. The court being closed on Wednesday. Further date will be a pretrial on July 29 in front of Judge Bryant here in 36th District Court. Thank you, sir. You can step aside.
Thanks, Magistrate.
So, Your Honor, you're not going to honor your Constitution?
Thank you, sir. Your hearing's completed, sir.
For DDC.
Every statute
All right,
is not law. I don't have to give my fingerprints. The Constitution
Okay,
states
Didi.
that.
All right,
Contrary-
Mr. Martin, can you hear us?
Yes, can I get the case number of the so-called case that never was given a copy of the ticket by the police officer, which he should have in violation of my due process right?
241-388 SM.
241, what else?
38 SM.
38
1388 SM.
24138 SM. Right?
Yeah, 2 weeks.
Okay. All right, thank you.
I do have in front of me a complaint charging with domestic violence violation of city code. It's misdemeanor. Oh, I see, January 24th, January 10th. Okay, you pleading not guilty, Mr. Gazicki?
That's John James Gazicki. Mr. Martin expressed his right not to be represented by a court-appointed attorney. He wishes to represent himself.
Okay. Is that right, Mr. Martin?
Present myself, yeah.
Okay.
Because I don't want to give up my right to be one of the sovereign people, as the U.S. Supreme Court said I have a right to be. So.
Okay. I'm gonna let you do that. I don't care why. Have you talked to the prosecutor?
No, I have not.
I want you to get the prosecutor and have her talk to Mr. Martin. And let's see what we're gonna do today.
Right, so I would like to talk to him right about how the case should be dismissed based on there's no evidence.
We're not gonna worry about that, Mr. Martin. I want you to talk to the prosecutor. She's gonna be online in a minute. Hear us?
Yes, I hear you.
Okay, Mr. Prosecutor, want to put your appearance on record?
And good morning, Your Honor. Omar, or good afternoon, Your Honor. Omar Shah on behalf of the people, PA 6332.
Okay. You've had an opportunity to talk to Mr. Martin?
That is correct, Judge.
Been able to resolve this matter?
Judge, there is no resolution on this matter. I had an opportunity to speak with the defendant in this case. He wishes to have a jury trial or a bench trial. He just doesn't know which one he wants.
Okay, Mr. Martin, which one do you want? I'm gonna set this over for a trial. You want a jury or the judge to hear it?
Well, I don't really want to answer that question. I don't want to be fraudulently presumed I'm consenting to any of these proceedings, you know. I'm not consenting to have my right against slavery violated by consenting to any proceedings. So that's why I kind of want to answer that question. But before I get to, as I notified the prosecutor, he should have dismissed the case due to lack of evidence. But I had one more thing I wanted to point out to the prosecutor. I forgot to mention to him. I want to mention to him now, and that is I want the police officer, Bardaway, who illegally arrested me. I want him charged for the legal arrest, which is assault and battery. And also Judge Shackelford, who did not give me a personal bond. I want arrested too for violating my right against kidnapping and allowing this unlawful incarceration of me, which I have a right to do. And if they refuse to do it, I'm also going to move for dismissal on the case because it's violating my right against equal protection, because I have the right to have charges brought against people who have committed crimes against me also.
Okay, based on that, I'm going to indicate that you want a jury trial. I'll set this matter over. I'll have the assignment clerk set a date. She'll send you a notification of the date for the jury trial. In the meantime, I'm going to continue your bond until that day. You go with the sheriff, he'll take care of you today.
Hold on, I have an objection. I have a motion to make that I have a right to a personal bond.
You file that motion in writing, and I'll take a look at it.
I already did file with the.
In the meantime, I want you to go with the sheriff, and he's going to take care of you.
Hold on, I object. I have some. I already filed it with the court. I'm making that motion now. I'm making that demand actually now because it's a constitutional right to be without guilty. All right, then I'll be taking your job. How about that? Because you violate my constitutional right, and I move to dismiss you off the case, disqualify you. Since you violate my due process right to a personal bond, then you showed your biasness, and you should not be in the case no more. I move to disqualify you. If you deny that motion, I request that you send it to the State Court Administrative Office. You're not supposed to continue my bond with monetary award. Shackelford illegally denied my personal bond, and you're not supposed to continue that illegal denial. I have a constitutional right to be presumed innocent, and that means the right to a personal bond. Article 3, Section 1, judges that violate the Constitution cannot hold office. So don't grant that motion if you want to, that demand. I'll be to get your job in a lawsuit. That's all I got to say. So you want to continue with that? Sound like they muted me, maybe. Well, these judges are gonna find out. They're not above the Constitution.
Hello? I'm on mute. Can you hear me?
Yes.
Okay, are they dismissing everything or do I still have the review cases or?
Just 1 second, sir. Mr. Evans, just 1 second. We're in the middle of something. The evaluator did opine that he should be evaluated by a DCR prior to release, and the court is adopting that, indicating they should be held until no later than noon on the 25th for that purpose. And that is, he was
so we got RB.
unable to proceed under. Mr. Mercer, does he have a history of one or more violent acts?
I don't know that we have out-of-state history on him.
Okay. And all I see here is the. Right.
Was I found competent or incompetent?
No, Mr. Evans, we're not, this is talking about someone else. Now we're about to address your hearing.
This is standard.
Okay. And this is City versus Sylvester Evans.
It's Andrews, it's showing the blue line.
082019.
Everybody can come out.
5525, 3A0549215, 4A0231898, 4A04725552, and 3A0312319. Have the parties had an opportunity to review the evaluation?
Yes.
Yes.
Did either party take exception to the court adopting?
I have an objection.
Object to the court adopting the evaluation?
What's the status of the evaluation? Was it competent or incompetent?
I'm not able to proceed.
So I mean they found me incompetent?
Yes.
Okay, could I see the paperwork on that so I can review it and have that challenged?
So just to be clear, if you're incompetent, everything gets dismissed. If you're competent, then everything proceeds.
So that's what I'm asking. Did the doctor find me competent or incompetent?
Incompetent.
Okay, under what circumstances? What was his reasoning?
Delusional thinking.
And what proof did he have on that?
I mean, the interview that he did with you.
Okay, and being that you said everything is dismissed due to delusional thinking by law, from what I read at the law library, it said being delusional in itself is not reason in itself to be declared incompetent.
That you are unable to assist in your own defense because of it. So there are two prongs, there are two ways that you can find someone unable to proceed, that they don't understand the nature of the proceedings, which you clearly do, and the evaluator said that. But that you were unable to assist in your own defense due to the delusional thinking.
Well, that's being with the letter that I sent to you, that would directly refute that, correct?
No, that supports that.
What the letter I sent to you, it had motions that I wanted filed and whatnot that would prove that I'm able to assist in my defense, correct?
No, it was, you wouldn't give me any information. You gave me half information about things, refused to give the further information when I asked in court.
I did declare that the information regarding the evidence, that was a matter of secret state privilege. And then I also declared that the motions that I want to file, I didn't have access to the law library to get the proper documentations.
I am adopting the evaluation over your objection and finding that you are unable to proceed in these matters. So the pretrial cases are dismissed. All of the reviews are closed pending a further finding of able to proceed. The evaluator did not opine that you should be evaluated by DCR prior to release, so you're just released today. You can appeal this. You're welcome to appeal this finding, this ruling, and you could come to the court and the clerks can tell you how to do that, what paperwork to file.
All right, so I'll be released from jail today.
Correct.
And also, can I get the paperwork of the evaluation from the doctor?
You represent yourself, so I think you kind of have a right to it.
Yeah, how do I get that paperwork?
Mr. Ionati, are we able to print that out for him?
You can print it off and give it to the officers to give to them.
Okay, we'll get that to you today.
Okay.
All right, thank you, Mr. Evans.
And also, I want to put on record that I want to file a notice to appeal to the Supreme Court of the state of Washington.
That's appeals from courts of limited jurisdiction go to King County Superior Court.
I understand that, but I want to bypass the Superior Courts and go directly to the Supreme Court due to the circumstances and the nature of the judgment.
Okay, you can try to do that.
I want it on record noted. If you
you
have
have to actually file it. That means nothing. You have to actually file the documentation. You have to file notice.
That's impossible to do from in here. You're saying when I get out, I have to file it?
Yes, correct. You'll have 30 days to file it.
Okay.
Okay. You should know though that you are still trespassed from the airport. Nothing in what I've done today affects that. That is the airport's trespass notice. It is still fully valid. You will be rearrested. Okay.
So even if I'm there on personal travel, I'll be rearrested.
You have to comply with their rules and restrictions. I'm not going to give you legal advice as to what that constitutes because you need to look at your trespass notice. But
yeah, I was there this time on legal business.
We're done. We're done with this case. This case is dismissed. So we don't owe me any explanations. I'm just telling you that the trespass order from the airport is still out there. Okay. I'm just letting you know.
Okay, so I can still be arrested under false premises because they also said I confessed in this case, which was not true.
I'm just telling you that the trespass order is still there. That's
okay.
All I'm telling you. Okay, thank you, sir.
Okay. Also, what I want to fire Mr. Ionetti as well.
He doesn't represent you. We've already gone through that. He doesn't represent you. You can't.
Okay, well, is he going to give me the paperwork that I need for these proceedings?
SCORE will.
Okay, and the evaluation as well from the doctor?
Yes, I believe we'll be printing that out. Mr. Ionati said he would print that out for you.
Okay.
All right, thank you, sir.
Oh, what is going on with the review cases? I guess I haven't heard them.
Closed. They're all closed, pending a further finding of able to proceed. If maybe
closed. What does that mean?
It means there are no affirmative conditions no conditions can be imposed because there's a finding of unable to proceed.
So they can be reopened later?
They can.
So I can have a warrant placed and I don't even know it once again?
Well, no, you would have to get notice of a hearing.
Like this time I didn't get notice of the review hearing and they placed the warrant out for failure to appear. I didn't even know I had a hearing on the review charges.
Okay. This is why it's very important to keep your address updated.
My address is very, I don't know, for lack of a better word, I do a lot of moving around, so I don't have a steady address that I can always get mail at the moment. So that's how we got in this position the first time.
Well, so that sounds like, I mean, if you're not going to let us know how to get in touch with you, then you can't complain when you don't get notice.
I can give you an email. Would you be able to contact me by email?
And I think we have that listed.
But they never gave me a notice of any hearing via email.
Okay. We will make a note, email only.
And I'm still confused as well. The case is open or closed?
Closed. He's unable to proceed.
And I'm confused by that. So the conditions were imposed. There's an allegation that he violated him. He's not found competent. We can't move forward in those violations, but it doesn't invalidate the conditions that were set because those were done at a time that he was competent. Like, is the court still taking jurisdiction? Like, I'm still struggling with that.
I can't impose conditions.
The conditions were already imposed, though.
I know, and they're stayed. Everything is stayed.
Sure. But so the case is open but stayed, or is it
I guess
closed?
that's maybe a better way to characterize it, but it's for all intents and purposes closed, effectively, pending a further finding of able to proceed.
And also, would I be able to subpoena any grand jury proceedings that may have taken place as well?
There are no grand juries in courts of limited jurisdiction, and I don't believe there are in Washington at all, other than federal.
Okay, okay. And so you said, yeah, I'll get a copy of the evaluation, and you say I got 30 days to start filing motions to try to get everything reversed, right?
At this point, your only avenue is appeal.
Correct.
Okay. All right. Thank you, sir.
So I think the city is objecting to them being closed in any way.
So they're not closed. They're just, I mean, I thought we talked about this.
I know, but when we're using words like closed, is there gonna be a CL for
No.
closed disposition?
No.
Because that's what's gonna be in the docket is they're closed. And so in a year or two, if this comes up again, it's gonna be very difficult to figure out what exactly happened today if we're
Well, in
using.
2 years, it's too late. Jurisdictions run.
Sure, there's some situations where that wouldn't be the case, but so the cases are open is all I'm trying to understand.
Yes, they are not closed. They're just.
Okay.
Okay, so would you be able to clarify that for me, Miss Your Honor, in layman terms, so I can get an understanding, because you're saying it's not closed, but it's open closed, which is kind of difficult for me to understand.
You guys are right. I should use more careful language. The cases are open. They are stayed, which means frozen, essentially, unless there's a further finding by a doctor that you are able to proceed.
Would that be able to be done in the appellate courts or the state Supreme Court, or overturning his findings, or what? How do you get the proceedings to be found? How do you get that overwritten, basically, what the doctor prescribed or diagnosed?
So, and this is interesting. It's a situation I haven't come across where there's an individual wanting to contest the finding.
Yeah, based on, I don't have the law library's information in front of me, but based on the information I got from the law library, a defendant cannot be declared incompetent by being delusional in itself.
And
that's
I explained to you what the evaluator opined, that your delusion is impeding your ability to assist in your own defense. That's what the evaluator, am I characterizing that correctly, Mr. Mercer, Mr. Ainati? That's what it sounded like to me.
In what way though? How is it impeding?
You're asserting defenses that don't exist.
Such as?
The stuff about the case in Louisiana.
I asserted evidence that has a seal on it. So the only way he can find out that it doesn't, what I'm saying is not true, is to get the seal broken on the evidence, which is under state secret privilege. And the only way you can get that broken is by orders of the president or Chief Justice Roberts of the United States Supreme Court.
So when you get all your ducks in a row to get that happening so that the court can see it, it sounds very far-fetched. I've never heard of anything similar happening on a state case that the U.S. Supreme Court would involve themselves, much less that any one justice would have authority to unseal something. I'm adopting this finding. You can appeal.
Is everything that we spoke about today on the record? Would I be able to get recordings of all the subpoena recordings of all the hearings, including what we're talking about today?
They are all online, available for you to listen to anytime you want.
Okay, and they all can be subpoenaed by the state Supreme Court and whatnot to be overturned or sealed. Also,
they are not going to do any investigation on your behalf. If you're appealing, you have to do all the investigation.
Right. No, I don't need them to do the investigation. Everything's pretty much said and done. The only thing is the assumption that you guys don't believe the evidence is under state secret privilege, and I am who I'm telling you I am. So you're believing I'm delusional. Am I correct?
That's correct.
Right. So y'all making assumptions that's not true, that I have to go through the process and get everything removed to the federal courts to prove that it's true, which is going to be under seal at that moment. But I'll give the state Supreme Court a chance to make the adjustments and override.
Okay, thank you, Mr. Evans. You'll be released today and you can get working on all that. All right, thank you, sir.
All right, so we're done here?
We're done here.